Good evening and welcome to the August 25th meeting of the Falmouth Zoning Board of Appeals here at Falmouth Town Hall. I'll forego the usual comments at the moment because we do have executive session scheduled for 6:30. So under Massachusetts General Law, Chapter 30A, Section 21A3, a meeting with Town Council relative to appeals number 61-20, Echo Land Development LLC, 0 Percival Road, Lot 4, in T-Ticket. And number 50-20M, Village of Brick Hill LLC, 511 Brick Hill Road, West Falmouth. And 102-21 Clower, 10 Beach Plum Path in Hatchville. So as the chair, I'm making the determination if the board were to discuss these matters in open session, it would have a detrimental effect on the board's litigation or negotiating power. So I will make the motion to enter into executive session, and we will vote to return back into public session at the close of executive session.
Mr. Chairman, I'll second the motion.
Thank you for the second. So roll call vote. Jerry?
Jerry Thomas, aye.
Morse, aye.
TJ Hurry, aye.
Scott Peterson, aye.
Murphy, aye.
Mark Finner and I.
All right, passes unanimously, and we will enter an executive session. If everyone could please exit the room so we can discuss these matters privately with town council, and we'll invite you all back in once we're done with that. Thank you. All right, good evening once again, everyone. Thank you for your patience through executive session, and welcome back. Calling the meeting to order once again, and I'll ask everyone to please silence their cell phones. We'll introduce the board, starting on my far right. Your far left is Jerry Thomas, who is an associate member. To his left is James Morse, who is the board's clerk. For what looks to be the very last time, my name is TJ Hurry. I'm the chair of the board. To my left is Scott Peterson, who is the board's vice chair, followed by Suzanne Murphy, who is a full voting member. And Mark Finneran is also with us tonight, but he's recused himself for the first continuation on the agenda. Also with us tonight is Noreen Stockman, who is the zoning administrator, and Ashley DeMello, who is the recording secretary for the night. The Zoning Board of Appeals is charged with applying the zoning bylaws for the town, and we consider requests for special permits, variances, and appeals as provided in the bylaws, which have been approved by town meeting and the Attorney General's office for the Commonwealth. All decisions the board makes are made through the public hearing process. The board's goal is to hear testimony from the applicant, from the public, and also to allow a full and fair discussion of the project prior to rendering a decision. To begin each hearing, the clerk will read the public announcement of the hearing and then present any pertinent information from the file, such as referrals from town departments and summarizing correspondences to the board. The applicant or the applicant's representative will then have 15 minutes to make a presentation, and time may be extended by vote of the board. The board will then question the applicant, and the public will be invited to comment as well. Public comment should only be directed at the project itself. We ask you to please refrain from making any personal or derogatory statements. Public comment can include an opinion in favor, in opposition, or it might just simply be a question about the nature of the project. The chair will limit discussion in the interest of time in the event that comments become repetitive. All members of the public wishing to speak should wait to be recognized. Come to the podium to your left here. We ask you to also state your name and address for the record. We do limit public comment to 2 minutes per person, and while you're up there behind the podium, we ask you to stay behind the podium and speak into the microphone. And speaking of the microphones, these microphones behind the podium in front of us, they do not amplify within the room. They're meant for the people watching on FCTV tonight. The board will then either close or continue the hearing. When the board is satisfied that enough information has been presented by testimony and in the file to make a decision, by motion and vote of the board, the hearing will be closed. And the alternative, we may continue the hearing to a future date and time certain. After the hearing is closed, no more testimony may be taken. And as for board's discussion and decision, the board may then further discuss the project among ourselves. We make a motion to deny or approve would be made and voted upon. Such a motion will include a summary of key findings and conditions. An affirmative vote of 4 members, which is a supermajority, is required for approvals of motions on special permits, variances, and appeals. A split vote, such as a 3-2 vote, would be a failure to carry and would result in denial of the project. Under Massachusetts general law, if a special permit is denied, the applicant cannot return to the board for 2 years unless the project is substantially different. So turning to the agenda for the night, we did have executive session at 6:30, followed by public comment, 1 continuation, 2 new hearings, and we have a few items on our open meeting agenda. So up first, we do have public comment. This public comment period is meant for anyone to say something that is not on the agenda. So if you're waiting to provide comment on something that is on the agenda, just wait for the appropriate time in the evening. So is anyone out there with something to say on something that is not on the agenda tonight? All right, seeing none, moving right ahead to our continuation, application number 54-22. Falmouth Housing Trust, Inc., 33 Pheasant Lane in East Falmouth, requesting comprehensive permit for a single-family dwelling. Voting members on this project are myself, James Morse, Scott Peterson, Suzanne Murphy, Jerry Thomas, and as I mentioned a minute ago, Mark Finneran has recused himself from this hearing.
So, Mr. Chairman, since the continuation from the opening of this hearing, 2 additions to the file. There's a letter from Attorney Kimberly Beelan to the zoning board and CC to the applicant, Attorney Laura Moynihan, concerning the appropriateness of any executive session. There's also a copy of Attorney Moynihan's presentation that was made to the ZBA at the initial hearing.
All right, thank you, James. And for the applicant, Attorney Moynihan.
Thank you, Mr. Chairman and members of the board. I didn't really have any comments for this evening. I think the board had wanted to continue the hearing to consider the matter. So at this point, we don't have any additional evidence or testimony other than perhaps a request that the application be considered on the merits of the application itself, which we think meets the standards for a comprehensive permit under the state statute. Thank you.
Thank you, Attorney Moynihan. Turn it over to board questions as we usually do to see if there are any. Jerry, any questions?
No, there's been no new information other than lack of executive session,
All right.
in which we didn't have.
James, anything?
Not at this time.
Scott?
None?
Suzanne? Nope. Attorney Moynihan, just to confirm in the P&S, paragraph 37 under additional provisions, the buyers acknowledge the 2 present lawsuits regarding the property, and the seller indicated that they shall secure a stipulation of dismissal in the event that this board approves this project, correct?
I have to refresh my memory on what it says.
Not to worry.
Which paragraph was it?
37.
You happen to have it there? It might be a little quicker.
I did have it on my phone, but I think I exited out. My apologies. It was attached to the application.
I have it here, counsel, if you'd like it.
Okay.
I have it here right here if you'd like it, counsel.
Oh, okay. Thank you. Sorry about that. It's been a number of months since I've looked at this.
Not to worry.
Okay, so closing condition 1, is that the question? 2 applications pending.
Correct.
Okay. All right, I think that provision was amended because obviously we're outside of the 90 days. So let me just see if I can find that for you. Is that what you're concerned about, is the 90 days?
Partially, yes.
Yeah, Okay, so there was a modification agreement entered into on the 14th of March, 2022. So that closing condition was amended to say, in effect, buyer acknowledges that there were the two pending applications. On or by April 29, 2022, the seller shall secure a court-ordered stay of the actions to permit time for the buyer and the seller to satisfy the conditions of securing permits and approvals noted below in paragraph 37. The seller then authorized the buyer to proceed with those applications. So the permits and approvals were number 2, the project eligibility letter from DHCD, which we've secured. Number 3 would be the comprehensive permit from the zoning board. Number 4, subsequent to receipt of the comprehensive permit, the buyer receives a valid and effective certificate of use and occupancy from the town for the dwelling. And within 30 days of satisfaction of those permit conditions, the seller would provide court-attested copies for recording of one of the following: stipulation of dismissal by the parties to the actions and/or court orders and/or judgments dismissing the actions, which in either case establish dismissal of the actions with prejudice. And those could be conditioned on conveyance of the premises to the buyer. So that was modified, I guess, because of the inability, or there was it was decided that a court-ordered stay would have to take place. So I can give you a copy of this for your file.
If you could, that'd be
Does that
great.
answer your question?
It does. It does
Okay.
clarify everything. Thank you.
Thank you. Thank you.
Any other follow-up questions from the board at this time? All right, moving on, public comment. Any question, comment, or concern regarding this project? Anyone from the public? Anyone at all? All right, seeing none, back to the board. That was quick, so I suppose the board doesn't have any sort of follow-up
No.
question?
No.
All right,
You want to discuss before we close?
we could close and then discuss
It's-
if the board is satisfied that we've heard everything that we need in
Yeah,
order to
I think
close.
we have.
Motion to close?
Second?
Motion closed made by Scott, and second, I'll give that one to Jerry. All those in favor?
Aye.
Aye.
Aye, passes unanimously, so hearing is closed. No more testimony may be taken. Board discussion? I can start us off if you'd like.
Sure.
Just to echo James's sentiment from the other hearing night, not too happy with how this project came to be, or how the history of the property with the denials on the planning board and through this very board many years ago, followed by the 2 pending lawsuits. But under Section 40B of Massachusetts General Law, there are guidelines by how this board has to review the project in front of us tonight. So with that having been said, I would be in favor of directing Noreen to draft a positive decision for this board's review and future vote, just given the complexities of this subject property. That is the reason why we continued it to this evening, so we could properly review everything in the file, potentially have special counsel weigh in, which they did not, and we did not meet with them in executive session. But at least on my own, I've reviewed the project thoroughly. So I think the board can come to a determination tonight.
Well, I guess I'll go. I agree with your overview, TJ. I think the fundamentals here outweigh where we would want this to have ultimately wound up, which was not to have the house built there, but the town obviously needs to have more affordable housing, so I'm in favor of that outcome also, that for Noreen to draft a decision for us to review. I agree.
All right, anyone else want to weigh in?
I'm generally in favor. I think Falmouth Housing Trust should be complimented for trying to resolve this issue. I don't think anybody's happy, but single-family house in a single-family neighborhood. So I'm very comfortable with it. And again, Falmouth Housing Trust did a good job.
Good. James or Suzanne?
I agreed with all your motions. I think our hands are pretty much tied.
Sure.
Agree with Noreen to start the draft.
All right. James?
I'll rest on my previous comments.
Had a feeling you would. All right. So with that.
Motion to approve with conditions?
I can make a motion to direct
Okay.
Noreen to
Okay, sure.
draft a
Yeah.
positive decision for this board's review at a future date. Happy to make that motion and provide some of what should go in.
And then procedurally, if you're not here, how's that work?
Procedurally, if I am not here in the future.
How's that
there-
work with the
there are
drafted
Fake news thing
decision?
again, right?
There are 4 members.
Yeah.
If my resignation goes into effect prior to the board voting on this, there's 4 remaining members who are able to vote. And under 40B regs, all you need is a simple majority.
Okay.
So I can leave it to you 4.
Through you, Mr. Chairman, would it be cleaner to have a special meeting for the purposes of approving it, or just waiting for the next meeting, absent our chair, who may or may not be here?
Next regularly scheduled meeting is September 15th, and my resignation goes into effect September 9th. So I'm comfortable leaving it to you 4. We would have to set up a special meeting in order to vote if you did want my participation in the vote.
Noreen, any thoughts?
It would be up to you folks. If you wanted to have a meeting, you could arrange one for the 8th, if you wanted to have the current chair participation.
Sending off.
I mean, since it's been unanimous, I mean, whether we have 5 or 4, it's gonna be 5-4 or 4-4. 5-4, 4-4. I think it's immaterial. But if the chair wants to weigh in, I defer to him.
I think you'd want to,
Did provide a resignation date in such a fashion so I could review the possible decision and provide comment prior to any vote by the board. So
Oh, that's,
did have that in mind.
okay.
so we could ready it for the 8th, and you'd be available?
If you wanted to schedule it and that could be my last meeting, I suppose. That could be arranged.
Okay.
Let's do it.
Make a motion to review the draft comments from Noreen on the 8th.
Alrighty then, setting up
Second.
a special meeting then. Alright, still need to provide Noreen with some facts to go into the decision. I think it's important to note the procedural history. Comments that I made a few minutes ago, the prior denials from the planning board and the ZBA all those years ago. 2 pending lawsuits in the land court. Applicant provided proper site control through the purchase and sale agreement. Application is for a single one-family home, existing with 3 beds, constructed in 2019. Applied for waivers under section 240, 67A, I think, minimum lot size and minimum average width. Property is conforming in all other respects, setback height and the overall story height limit.
The Water Protection District is in a coastal pond overlay district, not in a Zone 2, not in an area of critical environmental concern, district of critical planning or concern, wildlife corridor, accident prevention zone, FEMA designated velocity zone, or historical district. Concom, not required required.
Applicant provided DHCD letter, determinant of project eligibility under LIP.
Title V has been approved.
Mhm.
These are findings, right? Or findings and conditions.
As far as, well, we can keep that as a finding for now.
Properties in compliance with Board of Health regulations as to septic. Reference any comments in the file from various town boards.
The applicant represented as far as current affordable housing goes in town. We're currently at 7.2%. We're approximately 417 units short of reaching the statutory minimum of 10%.
Reference the previous decisions from planning, ZBA. Comments or concern from abutters at meetings.
Applicant will, well, seek to get a certificate of occupancy. I'm still confused as to whether they need a building permit, but I don't think you can get one without the other. And I don't think a building permit's been issued.
Couple little leasing.
Right, there are current tenants.
Do we have to have?
I think that was discussed, so that could go in there. All right, anything else?
I think we decided it was outside our scope if they couldn't get the tenants out in time. Is that what you just said?
I just asked about the lease.
Yeah.
Yeah.
Yeah,
I think it's outside our scope.
it would be, but just noting the current conditions, it does include the fact that it is tenant occupied at the moment.
Good point.
Any conditions?
Certificate of occupancy.
I was thinking since it's existing, there's not too many other conditions that we can impose.
So certainly you want to stipulate to the case dismissals, right?
Mm-hmm.
Yes.
Prejudice. No changes to the premises absent prior approval.
Changes, has to go back to the board.
No additional bedrooms.
All right, anything else for conditions?
Affordability has to be in perpetuity.
Mm-hmm.
Sales, any change in sale to be reported to the town, properly managed.
This
Not to be
particular,
used as VRBO or commercial purposes, short-term leases and such.
that's a good point.
Yeah,
That's a
so
good
you
point.
would prohibit that.
Yep.
It would have to be their primary residence.
Yep.
In a case like this, do we have FHT or ourselves being the right of first refusal? If the person goes to sell and they can't sell it? I don't know what happens to an affordable unit.
I don't know that the town is set up to be
Okay.
able to manage that at this point in time.
I just don't know what happens.
Briefly, if you could.
It's just information. DHCD is the agency that approved the site approval, so there would be a deed rider attached to the deed, which would regulate in the event of a sale, there would be a right of first, or requirement to notify the town. So in effect, the same type of right of first refusal that you see with any other affordable housing sale project. And there's monitoring through DHCD as well, so presumably those types of conditions would apply also.
Thank you, Attorney Monahan.
I mean, I suppose you couldn't, wouldn't harm to say that the town has first right of refusal. And
Sure.
then if there's not funding to manage that, then there's not.
You say per DCHD regs, whatever.
All right, anything else? All right, so I know I made the motion, but was there a second?
I'll second it.
All right, thank you, Jerry. All right, so motion directing Noreen to draft a positive decision for the board's review at a newly scheduled meeting of September 8th. Motion was made by myself, second by Jerry. All those in favor?
Aye.
Aye. Passes unanimously.
Step out, but I'll be back. I need a bio break, but you'll have 5 minutes anyway.
Just want to thank you for your patience and thoughtfulness on this application. I know it was difficult. I appreciate it.
Thank you, Attorney Monahan. Would it be inappropriate to take just a quick break? All right. We're going to take a quick 5-minute break. Thank you. On to our new hearings. We have application number 56-22, Mello, 30 Alderberry Lane in East Falmouth, requesting a special permit to remove the existing deck and construct an addition to the non-conforming dwelling.
Being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 48 of the Massachusetts General Laws, you are hereby notified that application number 56-22, Crystal and Aaron Mello, 30 Alderberry Lane, East Falmouth, Mass., have applied to the Zoning Board of Appeals for a special permit pursuant to Section 240-3C of the Code of Falmouth to remove the existing deck and construct an addition to the non-conforming dwelling on the subject property known as 30 Alderberry Lane, East Falmouth, Mass., being map 17, section 1, parcel 33, lots number 37. We have an application, Mr. Chairman. We have an authorization for Clancy Construction to appear on behalf of the applicant. For referrals. From engineering, the application was reviewed for impacts to public right-of-ways and public utilities. Alderberry Lane is a private right-of-way in this area. 2, any connections or alterations to public utilities would require permission from the appropriate town department. 3, project must not direct any stormwater runoff to public property, abutters, or public rights-of-way. 4, we recommend that the board add a condition that requires the addition of dry wells, rain garden, or other stormwater infiltration measure for the new roof area at a minimum. 5, not all existing structures on this property appear to be shown on the plans. Is the fence on the property, or does it extend into the town's parcel to the rear? We defer to the board if additional information should be shown on the plans. From the water department, the existing home is on town water. The existing service is 3/4 inch and not 1 inch as per current town standards. The flow or pressure demands in the home, if the flow or pressure demands in the home increase due to the proposed addition, the owner will have to upgrade the existing service to 1 inch. Assessors have no comment. Health department, no issues as the health department, from the health department, as the applicant proposes a new 4-bedroom septic that meets the setback title required in Title V. And Concom has no comments. The above referenced project does not appear to be located, appears to be located outside of Concom jurisdiction. Fire department has no issues with the project. No comments from planning. You did, Mr. Chairman.
All right, thank you. And a representative from Clancy Construction.
Sorry, first time here in front.
Welcome.
I had plans already here. It was on earlier. Oh. See, there's a password. Okay.
You can feel for them.
Perfect. Oh, thank you. Can everyone see that one right there? Perfect. First of all, thank y'all for letting us come up and talk tonight. I just want to let you know, Crystal and Aaron Mello, you already went through the particulars of the site itself. Crystal is here tonight appearing as well. Crystal and Aaron have been residents of this community for 3 years at this home. In addition to Aaron being a teacher at Lawrence Middle School and Crystal being a Falmouth postal worker, they are both foster and adoptive parents to 5 children. The reason for the addition is to actually have dinner together. They want to actually start enjoying a little bit more of the home with the adoptive and foster children that they do have. The addition we're applying for will greatly increase size of the kitchen and dining area, as well as create more space in a full basement. All 5 of the children will also be able to enjoy the decking area on the rear of the home. The existing lot coverage is 1,305.6 square feet. It's clearly under the limit. It'll go up to 18.56 with the addition, and the proposed lot coverage with parking, paving, and structures is 2,077.7, equaling 20.57%. And the reason for the expanded living space is the recent family growth. Do you all have any questions at this time?
Do you have anything more with the presentation, or?
No, sir. I thought
All
at
right.
this stage of the evening, I would keep it very quick and succinct.
Well done. All right, we'll turn it over to board questions then. Mark, any questions?
No, other than the fence on the new thing, it appears that the fence is not on the property. Is that any issue with us? No.
Having spoken with Crystal this evening, the fence they just put on, when they purchased the house, they put a fence up again where the one already was. More than willing to take it down or adjust it.
And other than that, I saw no new nonconformities, no increases. I don't have anything further.
Thank you, Mark. Suzanne, anything?
Is the shed staying
Yes, ma'am, the shed is staying.
exactly the way it is, or is it gonna be,
To my knowledge, it's staying the way it is. We have
Okay.
made no adjustments to it.
okay, thank you.
Scott?
Oh, Mark made the point. I think if we can make sure the fence is where it should be, everything else looks good from the applicant. Thank you.
All right. James?
No questions, thank you.
No questions?
All right, no questions for me, so public comment, any questions, comments, or concerns regarding this project? Anyone at all? Seeing none, back to the board.
I have one quick question. I thought James said that not all structures were shown. Did you say that?
It was a referral, yes.
Don't think
I know, when I drove up.
I walked around.
Engineering, not all existing structures on this property appear to be shown on the plans. Question is the fence on the property or does it extend into the town's parcel to the rear? We defer to the board if additional information should be shown on the plans.
I believe I brought amended plans to the office that showed the fence, and yes, again, we're willing to take that down or adjust it to the lot line.
And as far as the shed, I'll do whatever you want with the shed. I'll take it down, I'll move it, whatever.
It just looked like it need help to me, that's all.
Okay.
It was like
I have one just like it.
You haven't done anything different other
Okay.
than the fence, that's all.
So all structures are shown then?
Yes, ma'am.
Yes.
Okay.
All right, so that clarifies that. Anything else? Anyone like to make a motion?
Motion closed.
Second.
Motion closed made by James, second by Suzanne. All those in favor?
Aye.
Passes unanimously. Hearing is closed. No more testimony may be taken. And as for the board's decision?
Motion to approve with conditions.
All right, motion approved with conditions made by James and seconded by Scott. Findings?
So 240-3C, not more detrimental. Applicant seeks to move an existing deck and have an expansion. Property currently sits in a lot of 100 by 101 square feet in an agricultural zoning district, excuse me. Existing structures are at 12.92%, consisting of a 24 by 44 foot residence with an 12 by 18 foot deck. What is proposed is a 38 by 49. Testimony is that will allow greater use for the occupants and their 5 adopted children. Agricultural zoning district, not in flood zone. Testimonies, there'll be a new Title V system placed in, not in Concom jurisdiction. Yes. Which should be the findings.
Sounds good.
No opposition at the hearing or in the file.
Fence may have to be relocated.
Amenable to moving the fence.
Thank you. Thanks, Jerry.
There was a comment about dry wells from engineering.
That can be a condition, I would imagine, yes.
Yep. I have that as a finding. Condition. All right. Conditions then.
Per plans, revised plans submitted 8/15/22 in the file. Standard hours of work. Fence to be either relocated onto property line, taken down, or licensed by the town. From the Water Department's request, if necessary, upgrade service to 1 inch. Standard stormwater runoff. We want to have these additional levels.
And any permission from the
Well,
town, because it's a private road?
Don't think it's on the plan, so we'll leave it to the discretion of their engineer where to place the dry well.
Okay, yeah.
Anything else? Just might be it. Anything from this side? Nothing? All right.
So with a private right-of-way, you would not have, the select board would not issue a license.
That was against the town property, that's all.
It's in the back.
Oh, that's toward the rear
To the rear.
regarding the fence, right?
Back, yeah.
Okay.
All right, so if we're all set. Motion to approve with conditions was made by James, second by Scott. All those in favor?
Aye.
Aye. Passes unanimously. Good luck with the project. Okay, up next, we have application number 57-22, Hanley, 237 Old Main Road in North Falmouth, requesting a special permit to allow a conversion of the existing dwelling into 4 dwelling units, construct porch addition, and a detached 4-car garage.
Being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 48 of the Massachusetts General Laws, you are hereby notified that application number 57-22, Brad Hanley, 293 Hancock Street, Quincy, applied to the Zoning Board of Appeals for a special permit pursuant to Section 240-23B and 240-23G.1 of the Code of Falmouth to allow a conversion of the existing dwelling into 4 dwelling units, construct porch additions, and a detached 4-car garage on subject property known as 237 Old Main Road, North Falmouth, Massachusetts, being map 5A, Section 5, Parcel 12, lots 000C. File, we have authorization for Attorney Clower to act on behalf of the applicant. For referrals, revised site plan dated August 24th, correspondence. We have correspondence from Melinda Tondera. Planning Board asked us to draft a positive motion for our 8/23 meeting pending on receiving some revised plans. However, since Scott Schulter is away and can't review plans, we anticipate the motion being voted on September 13th. From Conservation Commission, no comments. From the Health Department, counted bedrooms on site with Emborselli several years ago. There was 10 bedrooms, so this project is not an increase in flow. The septic plan, though not thoroughly reviewing, seems adequate for the project. From engineering, the application was reviewed for impacts to public right-of-ways and public utilities. Old Main Road is a public right-of-way in this area. The applicant is currently in the process of permitting the proposed driveway. Submission of the board is the only item left for approval. 2, any connections or alterations to public utilities would require permission from the appropriate town department. 3, the project must not direct any stormwater runoff to public property, abutters, or public rights-of-ways. 4, project was reviewed for the planning board, attached our review memos. Planning board review memo dated 7/21 of 22. Engineering department references numerous plans. Sewage, the proposed subsurface sewage disposal system is subject to Board of Health review and approval. Water, no potable water information is shown on the plans. Adequacy of the existing service or connection of new services is subject to the Water Department review and approval. Parking and access, the project includes construction of a new driveway from Old Main Road. Note that this lot is currently accessed via an unpermitted driveway constructed when access to the driveway was on 39 Pine Street was discontinued. The proposed driveway will require filing a permit with the engineering division. We request that the board either require the applicant to obtain an approved driveway permit from the engineering division prior to closing the hearing for the special permit, or that the board will include the following condition if the special permit is approved. Quote, the applicant shall obtain an approved driveway permit and post any required bond with the engineering division prior to the start of construction. The applicant shall complete the work as approved by the engineering division of the driveway permit. We defer to Falmouth Fire Rescue if adequate emergency access will be provided by the proposed design. Based on a 4-dwelling unit with 2 or more bedrooms, 8 parking spaces is required per 240-14.1E, and 6 surface parking units, 4 parking spaces in the front of the garage, and 4 parking spaces inside the garage are proposed. It isn't clear if the parking areas meet the minimum requirements of 240-14.1G. There are no dimensions on the plans for the aisles. The parking space dimensions are labeled and show conformance with this regulation. The 14 parking spaces proposed, no accessible parking spaces are required and none are provided. With no accessible parking spaces required, no van accessible parking spaces are required and none are provided. Addresses would be issued for this project prior to issuing a building permit. Attaches a draft sketch of the addresses for use in planning and paperwork. Regarding grading and drainage, we recommend that erosion and sediment controls are included in this project to protect the public right-of-way from abutting properties. We recommend that the plans be revised to include a demarcated limit of work and include proposed erosion and settlement controls. We recommend the following condition be included in any approval. Construction of this project shall follow the town's soil and erosion sediment control standard conditions document, which can be found on the engineering division's page of the town's website, referencing the Department of Public Works Engineering Division, shall be replaced with the planning board, who would be the permitting authority for the project. Note, the engineering division will require erosion controls across the front of the property and construction entrance as part of the driveway permit. The proposed project is not subject to the town's stormwater regulations due to less than 1 acre of disturbance. Drainage calculations for the town's design storm were submitted, however, they are incomplete. No drainage area map was provided. Compliance with 240-13.1C cannot be determined. Site plan review. We defer to the board if the proposed landscaping conforms to 240-14.3. A zoning analysis table was not included to show how the existing structure conforms to setback requirements of 240-11.4. We defer to the board if this information should be added. Correspondence from Attorney Clower.
All right.
Mr. Chairman,
Yes.
just a disclosure, I'm familiar with this property. In 2000, I did an extensive exterior upgrade, looking at roof and whatever, but it's not for the current owners, and it's nothing that,
In the year 2000, though?
yeah.
So 22 years ago?
Yeah.
No, I didn't mean that negatively. So
Well,
no current financial interest.
No,
All
look
right.
at the house that I painted 22 years ago. Pretty good looking, isn't it?
So Attorney Clower, with that disclosure made by Member Finneran, I'm sure you're fine with him sitting on the application?
Not an issue from where I sit.
All right.
Good evening, Mr. Chair, members of the board. For the record, my name is Kevin Clower. I'm an attorney with Ahmet Clower Law Firm here in Falmouth, and I'm representing the applicants, Brad Hanley and Eric McLaughlin. They are the prospective buyers of 237 Old Main Road. I'm joined by Brad and Eric this evening. Also joined by Mike Borselli of Falmouth Engineering and Lauren O'Neill, the architect on this project. We're before you tonight seeking approval for conversion of an existing dwelling into 4 condominium units pursuant to section 240-23B of the zoning bylaw. As I'm sure this board realizes, this project requires multiple levels of approval, special permit from the zoning board, site plan review from the planning board, certificate of appropriateness from historical. We are in the process, as was noted in the referral, of the site plan review. We've been before the planning board with what I would call a good reception. We submitted the revised plan, which was revised in an attempt to address the concerns expressed by an abutter. The planning board seemed quite satisfied with the plan. However, they did want to wait for engineering's review and referral of the revised plan. We will be back before them on September 13th, at which point they have told us they expect to direct the town planner to draft a positive motion. I would expect that vote will be in late September. So if the 13th is the next hearing, I expect it would be the 27th would be the following hearing. And we are going before historical on September 6th. Given that the site plan review is not yet completed, and quite honestly, we submitted revised plans to the zoning board very late, which was today, I don't expect the members had a chance to review those plans, nor are we expecting a decision this evening. Instead, I'd like to use tonight as an opportunity to introduce the project, to discuss the plan, any questions or changes that the board might be looking for, and to hear what feedback there is, both from the board and from the public. So this project is at 237 Old Main Road, which is located really in the heart of the village of North Falmouth. It's walkable to the intersection of Old Main and County. The lot is just shy of 40,000 square feet. It's 39,894 square feet. It's in the RB zoning district, and currently it's a large dilapidated dwelling located near the front of the lot. The dwelling itself is conforming to setback and lot coverage requirements. In fact, the lot coverage requirements by structures is only 8.6. The only non-conformity on the lot is the shed at the rear of the lot, which is only 1.4 feet off the rear lot line. We are seeking to rehabilitate the existing structure, to convert it into 4 units, and to add a detached garage in order to accommodate parking. There's a number of proposed improvements involved in this, including the rehabilitation of the existing dwelling, a new 10-bedroom Title V wastewater system, and the addition of that detached 4-car garage, as was just mentioned. Section 240-23B of the zoning bylaw allows for conversion of a dwelling into up to 4 units with certain requirements. It has to be provided that the house was in existence as of January 1, 1980. The assessor's records indicate this house was built sometime in approximately 1812, so I think we met that one. There's limitations if the dwelling is within a water resource protection district or a coastal pond overlay. This particular property is not located in either of those. There can be no home occupations or borders, which are not proposed. There's no additional bedrooms over those in existence as of January 1, 1980. As was noted in the health referral from Scott McGann, he visited the site with Mr. Borselli and counted 10 bedrooms at the time. I don't think the house has seen many interior upgrades in quite some time. And the conversion should not involve a material change to the exterior of the dwelling. Though we have some minor changes proposed, I think they are minor in nature and certainly none that rise to the level of material change. Proposed garage is allowed by special permit, 240-23G1. In addition to these changes, the shed will be relocated, which will eliminate the non-conforming rear yard setback. As noted, we did submit a revised plan earlier. The only change to those plans really was an increase to the setback from the garage to the northerly lot line. That was increased from 11 feet to 15, and the garage itself was pivoted a little bit to move it further away from the lot line. There was also an addition of landscaping towards the front or the western portion of the lot. The building as existing and proposed will comply with setback requirements and lot coverage requirements both by structures and structures paving and parking. I believe this proposal is a good use of the existing development. It rehabilitates a historic, once beautiful home. I've long felt that as we talk about production of units and adding housing, that infill of existing development is the best way we can do that. And I think that this does that in a really tasteful way and makes really good use of this property. This is a walkable area, and it's well suited for the conversion of this nature. I believe that this project meets the criteria for special permits under 240-23B, 240-23G1, and 242-16. As I noted, I don't expect that we'll have a decision tonight, but I'd be happy to address any concerns or questions that the board might have.
All right, thank you, Attorney Clower. On to board questions. Jerry, anything?
No questions.
Scott? Oh, I'm sorry, James. I was already turning this way.
Reserve any questions after public comment.
Very good. Scott?
If Mr. Borselli could maybe come up and
Sure.
speak to some of the septic design, that's okay.
You want to describe it, or do you have questions?
Question. So we have the 10 bedrooms, 110 gallons per day per bedroom, gets us to the 1,100. And the design leaching capacity was at 1,127. So it seemed, and the comments were that it seems adequate. Is there any benefit to having a little bit larger leaching field, understanding that we have the 10 bedrooms? And I know that there was a proposed change, and I wasn't quite certain what that was, quite honestly.
Right. I don't think there's any benefit to making the leaching field any bigger than it is. It's designed in accordance with Title V, for 10 bedrooms. The soils are very permeable. It has a 2-compartment septic tank, which adds a second additional treatment. So there's really no benefit to making the leaching field bigger, in my opinion.
Thank you.
Anything else for Mr. Borselli while he's up there? Good.
I see you have the well on there. Is the actual well under the foundation that's there, or is it in another spot? When I found it, I didn't climb down in investigate. It's hard going over there.
Yeah, this is fairly thick vegetation. We did find it. It was pointed out by an abutter.
No, I found it.
We didn't go in it either. We didn't do any investigating either, mainly because it's ancient and I've been told it was probably used back when there were horses on the property to water the horses. So we simply noted where it is and that it'll be abandoned in accordance with the Falmouth Health regulations for well abandonment.
Actually, now, like I said, I spent quite a bit of time there. There was actually, and this property's been subdivided. The horse well was actually down in the paddock area, which is part of 39 Pine Street. There was the house was owned by Monica Dickens, or Charles Dickens' daughter. I mean, so there's a lot of stories going around. So that was the house, well, that served the house. I'm familiar with that.
Oh, okay.
As I said, the well doesn't necessarily have to be where the well house is. It could be in a different location. Is that gonna be found or searched for, or?
I was led to believe the well itself is in that structure.
Could be, like I said, I wasn't climbing in. I fell twice getting over there.
When the way that would go, if the project proceeds, that would be, that area would be cleared and stripped and investigated, and if the well, wherever the well is, it'll be found and abandoned if it's not in that. It serves no purpose. In fact, we didn't go through the effort of investigating it in detail because we knew it was gonna be abandoned.
All right. Any other questions? All set? All right. Oh, I'm sorry, it's mine.
And,
Go ahead.
not for Kevin. Under section 4 with the material changes, including architectural features. I found no definition of architectural features, so I looked up the one in the legal dictionary, which says architectural features shall mean any architectural elements embodying the style, design, general arrangement, and components of the exterior of any building structure, include but not limited to the kind, color, and texture of the building materials, the style, and the type of all windows, doors, lights, signs, and porches. So, it seems like there's a number of changes in architectural features.
So it doesn't say that there can't be any changes to the architectural features. It says there's no material changes to the architectural features.
Well, materials, okay, and then I went to the Historic Commission's regulations, and their definition of exterior architectural features, any portion of the exterior of a building or structure that is open to the view of the public street, public way, public park, or public body of water, including but not limited to the architectural style and general arrangement and the setting thereof. And again, the same texture, building materials applied to the exterior surfaces, windows, doors, lights, and other pertinent features, exterior features. And I understand we have latitude, and I'm new, but I stopped counting at 27 architect, including dormers and other. And then if you go on in that definition, it's not to exceed the gross floor area of the dwelling unit. And then if you go to the definitions in dwelling, sorry, I shouldn't have this, but, and that's, the dwelling had one dwelling unit in it, and it says a room or enclosed floor space within the dwelling used or intended to use for the family for household living, sleeping, cooking, and eating. And, as I say, I know that we have latitude or whatever, but that definition seems to me, on the surface anyway, to preclude the use of the garage, the potting shed, and the greenhouse in the back because they weren't used in the past as habitable area. And I know we have to go to historical and all that, but they're just things that I'm pointing out that don't seem to.
Well, I'd be happy to address some of those questions, Mr. Finneran. So what it talks about is, it talks about there's no change to the gross floor area. Our bylaw doesn't actually include a definition of gross floor area. It does have a definition of leasable gross floor area, which is the sum of gross horizontal areas of all floors of all buildings on the lot, measured from the exterior faces or walls. When we talk about the conversion, we're talking about the dwelling itself. We're not talking about the potting shed or anything like that. So when we talk about the dwelling, the footprint of the dwelling is not changing. The gross horizontal areas of all floors of that dwelling are not changing. So I don't believe that there is a change in the gross floor area of the dwelling, which is what the bylaw is concerned with in that conversion bylaw. Relative to the changes or the architectural features, there are, anytime we are upgrading a property like this, there of course have to be some changes. There has to be changes to the siding or paint or whatever it may be. We will be going before historic to make sure that those changes are appropriate, but I don't believe those changes are germane to the conversion itself. They're not required for the conversion. They'd just be required for an update to the building. So the bylaw says there's no material changes to the architectural features. It doesn't define what material is, so that's a subjective call. The board has the leeway there to make that decision if they feel that these changes are material or not. In speaking with the architect and speaking with the team at length, we don't believe that these changes are material, but would of course be willing to hear the board out and whatever questions or concerns you might have.
And as I say, I'd be interested in historical's input on that, and, you know, I understand obviously you can't keep the building as it is. But on the second point, as far as the dwelling unit thing, and I mean, just by these definitions, I'm just trying to make them all mesh. I don't think that anybody was living, sleeping, cooking, or eating in the garage and potting shed and greenhouse.
We're not trying to include, so if you.
But they are in the, you know, that is basically unit 4.
When we talk about the garage, I just want to be clear. So this is the existing building effectively. The garage, of course, is new. The garage, but that.
No, the garage in the existing house. The end of the house. Move your cursor down.
Right, are you talking this?
The potting shed.
Okay.
To the left of that, right there,
Okay.
from that line over, that is, that's actually.
Okay,
the small-
I follow what you're saying.
Yeah, and that part, and then the garage is that larger part. And-
So, I mean, this would be a new interpretation for me, because every time we've looked at a conversion in the past, and we don't see them very often, quite honestly. It's been
Yeah,
a
there are
few-
not enough of them, if you ask me.
It's been a few years since I've done one. You know, we've never separated out a section that's the garage or a section that's the living area. We've looked at the building as a whole. And that's what we're doing here. We're trying to take this building and find a way to make it a useful building that's gonna serve a new purpose, but honor the old one, and be done in a way that conforms to the bylaw.
Yeah, and I understand that, but I mean, these are the definitions, and it just doesn't meet, and it doesn't mean that,
So.
doesn't meet the definition of dwelling unit. It precludes using the garage and the greenhouse by the definition of dwelling unit.
I would respectfully disagree that it would preclude
So
that.
do you think that people ate and slept in the garage and the greenhouse?
I don't think anyone would argue that this building as a whole is a dwelling. That's the question, right? This building is a dwelling.
Yes,
And that's what we're
but
looking at.
it's also one dwelling unit, would you not say?
Well, right now it is.
Yeah,
And
and
now-
then if you go further down to the definition of dwelling unit, and I don't mean to be,
No, I
to belabor this, but I'm just trying to make everything, you know, meet by definition, and by definition, nobody slept, lived, ate, or cooked in the garage or the potting shed.
So as it stands today, there's one dwelling unit on the property. The house is the dwelling unit, which includes an area for garage and includes an area for potting area or the atrium. That doesn't suddenly become not part of the dwelling when we're talking about this. Now, under the
Well,
conversion,
it does by this definition.
well, we're conflating definitions, because the dwelling is the building as a whole, which is,
Yes.
the building intended for living, sleeping, eating, cooking.
And that fits but below dwelling, it's, a subset of that, it's that building
So,
as it was
I think
one
it's-
dwelling unit,
I think,
correct?
I think we're looking at two separate things here. So the dwelling, as it exists, is a dwelling. What we're doing is creating 4 dwelling units.
I know, but, it just, and again, I don't want to belabor this, and it's coming, but it was one dwelling unit as it existed from 1812 and as it was at 1980. You agree that it was a dwelling unit?
Yes,
One.
this is one comprehensive
Yeah.
dwelling unit.
And then, if you go to the definition of dwelling unit, it precludes, or it's area that's used for living, sleeping, cooking, and eating. And I have to just say, and now this will be the last, that nobody sleeps or cooks or eats in a greenhouse or a garage.
So let me just play out if we were to follow this. So if they were to do that, you would say that they could keep that garage in the greenhouse, and only convert the remainder of the house.
Well, that's what the definition says here. But we're the zoning board of appeals
Sure.
and we have latitude.
I don't-
But I just want to be factual.
Sure,
And you're going to find that that's the way I'm always going to be.
Understood. Again, I would just respectfully disagree, because I think we're conflating two issues here. The house as it stands, in my opinion, is one singular unit. The conversion bylaw allows for the conversion of a dwelling, which the house is, into up to 4 units. And the 4 units proposed don't include that garage. That's to be converted. That's part of the conversion process.
Again, all right, then this is the last time. A dwelling unit is a room or enclosed floor space within a dwelling used or intended for use by one family or household living, for household living, sleeping, cooking, and eating. And again, and this is the end of it, I'm just saying that people didn't live, sleep, or eat in a garage or a greenhouse.
So I think I can potentially answer this question. If we were claiming that there were 2 existing units, if I was saying there's 2 dwelling units, because the definition is a room or enclosed floor space within a dwelling. So that would, if I was saying there's 2 dwelling units currently,
But we have to deal with it at 1980, do we not?
sure, but I'm looking at, I'm trying to understand and to get to what you're saying. If I was to claim there's multiple dwelling units, that would be a unit within the house. This is a dwelling, and the bylaw allows for the conversion of a dwelling into up to 4 units.
I am not arguing with that at all.
Okay.
But again, all right, I don't want to go any further, but as it sat in 1980, it was one dwelling unit. And then by our definitions, it precludes the use of the non-living area. And I know we got to go before, and we'll be back, so I don't want to waste the evening on that, but my question still hasn't been answered to my satisfaction, but
I don't really know how to answer the question, because I think I have, and apparently we're at a little bit of a loggerheads, and I don't want to.
no, but don't you have the definitions in front of you?
I do, but I think you're looking at 2 different definitions that mean 2 different things.
No, a dwelling, and then a dwelling unit,
So,
nobody, do you think that people lived, ate, or slept, or cooked in the garage or the greenhouse?
I don't think they had to under the definition of a dwelling, and the conversion bylaw isn't for the
I'm
conversion.
talking about the definition of dwelling unit.
I understand, but the conversion bylaw doesn't allow for the conversion of a dwelling unit into up to 4 units. It allows for the conversion of a dwelling. This is a dwelling. So I think that does answer your
It's
question.
also, but would it not be also one dwelling unit?
No, because a dwelling unit's within a dwelling.
And that's a dwelling, and it's only a one unit,
So,
I'm sorry,
so a dwelling unit pertains to if you had multiple units, if you had a condominium, like we're trying to do here. If you had a building that had 16 units, you'd have singular dwelling units. This is a dwelling. The bylaw allows for the conversion of a dwelling into up to 4 units. It doesn't allow for the conversion of a unit into up to 4 units.
But, okay, this is where we disagree. That's a dwelling, but as it was in 1980, it was one dwelling unit.
A dwelling and dwelling unit, two separate things.
I'd say a dwelling unit is a subset of the dwelling. I mean,
I don't think it's a subset. I think it's a separate entity unto itself. So a dwelling unit, again, would be a smaller unit in a larger building. So if you had 4 units here, as we're discussing, that would be, each would be a singular dwelling unit. This building, this house, is a dwelling.
Attorney Clower, if I could suggest something that might answer the question, because I know we're moving to a continuance. If you could maybe perhaps come back, showing some examples of other conversions where something similar was adopted by
Sure.
this board. I think that might be somewhat helpful for the.
Yep, I can certainly bring a few examples.
Do you have a date set at this point for historical for your hearing?
September 6th.
September 6th. And I know it's not a zoning, but it's just a concern for safety-wise, anytime the density of a building is gonna go up. What are the current fire regulations in terms of smoke monitoring and fire detection?
I would defer to the architect on that, but we'll be complying with whatever the building
I'm sure
code
you
and
will.
regulations are.
Always a concern with.
You know, there's certainly fire separation between the units. I don't pretend to know exactly what those regulations are. But, you know, we'll be going through the building permit process, working with the fire department, working with the building department to make sure that anything that's being proposed is done in an appropriate manner.
Thank you. Thank you, Mr.
Chair.
Chairman.
I have just one more thing, and as part of studying this and my homework, so to speak, I've gone to a few different completed projects and asked the people there what they thought were issues that weren't completely dealt with at the time, and they're unsatisfied with 2 and 3 and 4 years down the road. And the two things that came up most were snow removal and trash location. And, you know, one of them had a problem with the snow piling up and icing, and numerous ones actually had a problem with the garbage, you know, a dumpster not fenced or whatever. So is there a plan for, or will there be a plan? And I'm not even sure that this is actually our purview. Like I said, I'm
I
the
think
new
that's
guy
certainly
on the
something
block.
we could discuss and address at the next hearing.
Okay, I just.
I
so
don't want to say something just for the sake of saying something.
No, I mean, just to bring it, because I might ask it next time, and I mean, it seems kind of reasonable
It's
to me.
a fair question, so we
Yeah.
can, I'll discuss that with the applicants and see what their proposal is for that.
Fantastic. Thank you.
Thank you, Matt. Any other board questions at the moment? All right, public comment. Any questions, comments, or concerns regarding this project? Sir?
My name is Tony Petrucci. I'm at 243 Old Main Road, direct abutter to the north of the property. And I am, for one, very happy that somebody is going to rehab this building and save some of our architectural heritage in this town. However, I have a couple of questions, and I only have a couple of minutes here. One is how they came to 10 bedrooms that existed as of 1/1/1980. Right, because the Board of Assessors says there's 6. In 2005, they said there was 5. So how did they arrive at 10? Well, Mr. Borselli met with Scott McCann, the health agent, who used the Title V definition of a bedroom. That Title V definition of a bedroom states that it is a room providing privacy, has 70-plus square feet of floor space, a window, and has electrical service and ventilation. Now, the key term in Title V is the rooms are intended primarily for sleeping. Well, if you look at the floor plan that was provided for the sale in 2018, it's pretty hard to count 10 rooms that might be intended primarily for sleeping. So I have to ask the question how we got to 10. Because if you can't exceed in the conversion what existed as of 1/1/1980, 10 seems to be made up. Now, the Board of Assessors does not have, they don't have any records going back to 1/1/1980. In fact, they told me they didn't even mark down bedrooms in those days. I'm told that, and it's not anywhere in the zoning code, that without that, then you turn to Title V. Again, the rooms are intended primarily for sleeping. If you look at the old floor plan, because now it's been gutted because of a water leak, so you can't go through it today. But if you look at what was used for sale at the time, and it's hard to come up with 10 that would be intended primarily for sleeping. So I'll just leave that. Now, again, I'm very happy to see this project go through, and I'm right next door to this. Now, also, the existing septic system has not been sized for 10, so I could have 10 bedrooms at the time. Now, as it regards material change, Webster's says, material change equals important, essential, or pertinent. Now, what are the material changes that Mr. Finneran was talking about? There are second floor decks being added. There are 2 dormers being added up top. Those dormers, without those dormers, you can't have the unit right there in the front. There are 4 new entrances. Those are material changes, which will come up before historic as well. So the definition said conversion shall not involve any material changes in the exterior of the existing dwelling, including architectural features. Those are architectural features. So I'm very happy. I want somebody to do something with this building. But if it's gonna be done, let's follow the zoning ordinances. So I hope you'll consider what I've had to say tonight.
Thank you for your comments. Anyone else with any other questions, comments, or concerns regarding this project? Yeah.
Hi there. Thank you for staying so late. I'm Priscilla Garrity. I'm at 229 Old Main Road. I used to abut the Dickett's house, but they subdivided it. So now 39 Pine has a driveway or a parcel of land that separates us. But my house is 1776, the Old Nye Tavern, and quite familiar with all the other houses in town. In fact, my great-grandfather used to own 237 and sold it to Monica many years ago. But I'm here to let you know that I'm very concerned about how the town is approaching the affordable housing. And do you have a comprehensive plan on how to approve each and every one of these individual conversions, condo developments, et cetera, et cetera? As being a villager I'm 4th generation, and the little guy over there is 6th generation. In North Falmouth, we like to stay up in North Falmouth because that's where the family's always been. And in fact, the house that I own is one of the houses that I think my family has never owned. It was owned by the Nyes up until about the 1950s. But I just want to show you a plan of what I call the triangle, which is Old Main Road, County Road, and then Pine Street, which is basically abuts the 4 corners of the village. My great-grandfather's building, the Rand building, is right there on 4 corners. My grandmother's house that was in the family for over 100 years was converted to 8 units on, which is now 90 County Street. And if you look at the map of all the multi-housing in that triangle, it's pretty staggering. And you're asking, this is tonight is just the 237 Old Main, and this one is going to be in your zoning board of appeals soon too, I think. But if you look at the density of this, I ask who's in charge and who's overseeing this. So this one up here, this is the 8 units that used to be my grandmother's house. The 4 units are apartments. I don't know how long they've been there, but they've been there for quite a while. This is the conversion for 5 units at 259-263. This is 237, conversion wants to 4 units. This one's me. And in fact, when Monica went to sell, when she got older and was selling and going back to England, she sold her pastures one to Tony, one to this unit back here, which is 2 units, again, multi-housing, and then one to me, or Fern Eldridge, who used to own the house before we bought it. And that was really for preservation, more than anything. I've never built on mine. Tony built a beautiful home on his, which sits back here. Okay, and then over here on Pine Street, we have a conversion to 8 units, and that was the old Rand Hill Inn. I'm a Rand descendant. And that's the old Rand Hill Inn that they converted, or you all might remember the Fraser Nursing Home. Now, this looks a lot better than what it was, but I'm just pointing out the density that you're putting on the village of North Falmouth. And as a former president of the village of North Falmouth, we don't really speak to too many things, but we do like to bring up the fact that we love our village the way it is. We're very in favor of affordable housing and where it exists. In fact, I've donated to the Housing Assistance Corp and also have built Habitat for Humanity houses and donate to them as well. But do you have a comprehensive plan so that you're not overburdening one particular area? I'd love to see a comprehensive study, if there was one done. And if you look at the general overall map of North Falmouth, too, you've got another proposed being built right here, the Wild Harbor condominiums. There are 14 there. 4 are affordable. You also have the apartments that are being built on North Falmouth Highway. And then you have another 10 apartments up here, right behind, across from the ballpark. So when you talk about parking spaces, and you talk about density, and you talk about impact, look at the whole picture, not just the one, which could be compliant. We all want to see Monica Dickens' house restored. We love that. But consider the density for the rest of the village. Thank you.
Thank you, Ms. Garrity. Just to briefly address
Sure.
your comments, as far as the town's overall planning goes, specifically toward affordable housing, there is the local comprehensive plan, which does involve a great deal with affordable housing, how to address that, concern.
And you're up to 7.2%, which is great.
Right.
Much better than you were before.
Mhm.
But taking a Band-Aid approach is not considering, I think, the overall.
Understood, but there's a couple of concepts at play here. Affordable housing in the 40B sense, that's a comprehensive permit done under MGL 40B, which is separate and apart from the
Sure.
bylaws applied for by the applicant tonight with this conversion. There are no.
Oh, I know, well, sure.
Right, so there is no affordable housing component
No, there
to
isn't.
this bylaw.
I know that.
But I hear you, I understand your concerns, and thank you for your comments
All
tonight.
right, thank you. Thanks for your time.
Any other member of the public with any other questions, comments, or concerns? All right. Oh, sorry. I didn't quite see you there. Come on up.
Hi, thanks for having me. My name's Dr. Shauna Wilbur, and I live at 15 Dairy Lane in North Falmouth. I'm personally very concerned because the current plans are missing some significant trees. In particular, a Douglas fir that I believe was taller and older, or currently is taller and older than the copper beech tree that my great-great-grandfather built or planted when he owned the property. And I ask that you please review and ensure that these historic trees remain on the property and are protected. Thank you.
Thank you. Any other public comment tonight? Making sure I'm not missing anyone now. Okay,
Mr. Chairman,
back to the board. Yep,
can I ask one more question?
of course you can.
of Kevin?
Yes, sir.
It's not on my, what was the gross floor area in 1980?
I don't have the figures directly in front of me. I think they are included in the architectural plans. We're not aware of any change, any recent changes to the plan, so all we have to go on is, the plans that have been prepared. Or do you know if we have that figure on the plans?
It should be on the architectural site plan, which is three. It's not actually, I don't know why it's not there.
I didn't see it.
Yeah, I'll have to get that figure for you, Mr. Finneran.
And as well as the proposed, because obviously they're different, just the.
So there are, the proposed, I do know is slightly larger, but that has to do with the way floor area is measured under the building code as opposed to the way the floor area is measured under the zoning bylaw. So under the zoning bylaw, it talks about the gross floor area of all horizontal floors of the building. Under the building code, you only measure areas that are above a certain ceiling height. It has to be, I don't know exactly what the ceiling height is, 6 feet or something to that extent. So the way it's measured for architectural purposes is slightly different than the way it'd be measured for the zoning bylaw. But we can make sure we have both those figures for you at the next hearing.
Yeah, it would help the way, because just looking at the prints, you could tell that it's increased with the dormers and the 1.5-story addition or whatever, and believe me, I'm all for.
Yeah, but we can certainly have those figures for you.
Thank you.
All right. Any other follow-up questions from the board?
Do you have any clarification there? You stated there was no footprint change to the house?
What's shown as the atrium out here in the back is being pivoted slightly, the same exact gross floor area. But again, that's an area that's, invisible from the street. We've taken a position that that's not a material change. The board can, of course, disagree with that. But the floor area of the building, or the footprint of the building itself, the dwelling, is remaining the same.
Anything else from the board? All right, so it looks like we are, our Attorney Clower, I don't know if you want to address any public comment tonight?
Mike was going to speak to the question about the bedroom count.
So regarding the bedroom and the definition of bedroom, so Title V has definitions of bedrooms, and the abutter did read the definition, and it sounded, as I understand it, and the phrase intended for sleeping is in there. But Title V is the state sanitary code, and it's enforced by the local health department and interpreted by the local health department. And all the health departments that I've worked with in the towns on the Cape look at rooms that not only are intended for sleeping, but have the potential to be bedrooms as bedrooms. So, for instance, a home office, if you try to call a room an office or a study, it's a bedroom. So when we look at Title V flows and bedroom counts, we count rooms that are either bedrooms intended for sleeping or had the potential to be because they meet the definition, other portions of the definitions in Title V for bedroom. So the rooms, when we were looking at this property as it relates to designing a septic system by a previous owner, we knew the assessor's records were inaccurate. The assessor's records are very commonly not in line with what the true number of bedrooms are for different reasons. So the way you solve that problem is do a walkthrough with the health agent. He's the authority that decides on the bedroom count, and that's what we did so that we were sure at the time when there was a different plan for a renovation that we had the bedroom count proper for the design of the septic. So I walked through it with Scott. We both agreed there's 10 bedrooms by the definitions used.
So that'd be existing or potential. I mean, if a room was hollowed out, like you say, it might have been previously an office building, but it met the definition, could meet the definition of bedroom.
Their walkthrough was before the water
Yeah, the walkthrough was done before the water damage occurred and the gutting occurred. It was
you
when the
saw
house
that-
was still intact. That was like
If it's 6.
2018, I believe. I can't remember exactly, but it was a while ago.
So it wasn't gutted, you actually saw everything?
I saw it with fully furnished, yeah.
Okay, thank you.
Bedroom, beds in rooms.
Is there anything else you wanted to address, Attorney Clower?
No, I think, we have a few questions that we obviously need to get the board answers for. I think we need to come up with some examples and some more information, which we're happy to do. If the board has any more questions, happy to address them. Otherwise, I think we have our marching orders.
We typically don't go back and forth with public comment, but if you do have something brief, I'll allow it.
Yep, okay, do I have to get up there?
Go ahead.
Yeah, sure.
Mhm.
Just for clarification, Jamie McDonald, 244 Old Main, to Mr. Borselli. I'm just curious, it's very nice for him to say that, but where's the health agent? Isn't he supposed to explain that? Yeah, well, okay.
Right, so,
I'm talking
it's
to
all
the
right
board.
yeah, talk through the board.
Yeah, so wouldn't the health agent, I mean, he's the one who's representing the town. Wouldn't he be the one to explain that?
Right, so each department, this board or the staff sends out referrals to each department for their comments on each project. So we do have a referral from the Board of Health, which James is trying to find at the moment.
Well, great, I just think it's pretty weighted if you just do it that way. Thank you, that's all.
You're welcome. All right. So Attorney Clower, it looks like we are looking at a continuance here.
So we are back before the planning board on the 13th. They're not going to vote a decision that night, but will be, I believe, directing the planner to draft a positive decision. And again, we're before historic on the 6th. So that should give us an idea of, a pretty good idea of where we stand by that point. So whatever the board has open, we're certainly open to those dates.
So given those dates, you're probably looking for something a little further rather than
What do we have for September hearings?
September 15th, September 29th, and then October 13th.
I think the 29th probably makes the most sense.
All right. Would anyone like to make that motion then?
Motion to continue the hearing until September 29th.
All right, motion was made by Scott and seconded by Mark, was that you? Yes. All right, all those in favor? Aye, passes unanimously. Thank you for your time tonight, Attorney Clower.
Mr. Hurry, on a personal note, I missed the announcement earlier, but I hear that you're taking leave of us. It has been a real pleasure presenting before you for the last 8 years, and I wish you the best.
Thank you very much. It's been a pleasure to serve. All right, on to our open meeting items. We have voting the minutes for July 28th and August 11th.
And we're tabling the 11th.
Tabling the 11th, 28th then.
Motion to approve, July 28th.
Second. I didn't receive them.
I didn't get him either. I don't think I got him either.
I don't believe I did. I went backwards looking for the agenda, and I don't believe.
I don't recall. We can just table it and do next.
Table both?
Okay.
I'm not a stickler for minutes.
All right, board updates?
That would be you.
Yeah, I think everyone knows by now. I've submitted my resignation
I didn't
to
even get
the
enough
select
time to
board
learn
last
and
night.
you're leaving.
So that will go into effect September 9th. It's been a pleasure to serve with everyone. Like I said in my resignation letter, Select Board has a long history of appointing good, well-qualified candidates to this board, and it's been a pleasure to serve with everyone throughout the years, and especially to Suzanne and Mark. I know our time has been a little short. I wish it was a little longer, but I know I'm leaving the board in capable, well-qualified hands, everyone who's sitting at this table, and staff included. So it's been a real pleasure to serve with everyone, and I'm sure you'll see me soon.
What town you moving to?
Sandwich.
Are you?
There might be a lateral transfer, I don't know. There's two vacancies on a familiar board in that town, so.
Good.
We'll see, there are, yeah.
Good for them.
We'll see.
It is good for them.
Long-standing members, much like this board, but there are two vacancies. Unfortunately.
For the moment.
Thank you for the service.
Thank you. All right, any other board
So
updates?
I would just propose for the board that you would not elect new officers until you have another full-time member. That being said, you need to appoint an acting chair in TJ's stead until you have an election. So I think it would be wise to do so.
I think if that's the case, I would nominate Scott Peters.
I would say, don't do anything at the moment. Put it on an agenda item for
September 8th.
September
Eighth.
15th.
Oh, after you, yeah.
Yeah,
You
yeah,
can't
after.
have, can't
Right,
have
so-
two. Well, you could, I suppose.
No, but I think Noreen brings up a good point, but might be other board reorg too. If one person goes to be chairman, then we might have a vice chairman or a clerk or secretary that has to be backfilled, so maybe we use the word board reorganization.
That's
Or
true.
potential board reorganization.
All right, well, you can put it on for a future agenda item on September 15th and discuss among yourselves.
Brilliant.
Got himself out of that one.
Board discussion, anything? Future agenda items? All right.
Covered it.
The next scheduled hearing is September 15th, but we did schedule,
September 8th.
we did review vote for a special meeting on September 8th for a review and possible vote on 33 Pheasant Lane, so
That's
see.
a meeting, not a hearing, right? It's just.
Well, the hearing.
I'll open discussion, I don't know, we want to.
Discussion among the board itself, hearings closed, no more testimony can be taken for anything, so, review of the draft decision and possible vote on September 8th.
And that has to be done here, or
Virtually,
the Zoom?
I think the vote, well, we didn't specify, so I suppose it does have to be here, right?
versus virtually.
I think so.
Okay.
All right, so, meeting adjourned, see everyone September 8th.